Good morning, everybody, and welcome to the Local Government Training Partnership session today. It's been a while, hasn't it, since we are all last met up, and I can't even remember the last time we had an in-person LGTP event. But the last year has been tricky for all of us, so it's nice that we can all get together, albeit virtually. We are looking to do some in-person events, probably, well, it will be next year now. So I think it's a question of watch this space whilst we work out what we are able to do, what we all feel comfortable doing, and you know, what you as the members of LGTP want to do. I just apologise for that. That was my husband coming in with some sustenance because I've not had much breakfast today, so sorry about that. He's now gone, he's now left the room. These are some of the delights of working from home, aren't they, that we've all got used to in the last 18 months or so. Anyway, my domestic setup aside, today we're going to start the day with an employment law update, which is really all about issues that have come about because of COVID, and there have been many, and they've now found themselves trickling down into the employment tribunal scenario. So there's some interesting case law that has been generated as a result of COVID, both in terms of employment and sort of health and safety type cases. So I'm going to run through all of that this morning, and then my colleague Vicky Bowles is going to do an update on information governance. I'm very aware that this is sort of everybody online, and so we're going to try and make it as interactive as possible. So we've got some polls coming up that we'd like you to engage with, if possible, and Emma will be helping me with those. We will be having a bit of a break. I'm just looking at my notes now. So I'm going to be speaking until about 10:30. We'll see how it goes, see whether people need a bit of a comfort break and an opportunity to grab a cup of tea or a cup of coffee, and so on and so forth. So and then I'll get going again, and then we'll have and then I'll introduce you to Vicky, and then we'll have a break then. But I think we'll probably play it by ear a little bit in terms of when we time the breaks, just so that we can make sure that they coincide nicely, or there's a natural break in terms of some of the subjects that we are covering. Anyway, I will get going. So Emma, if you could take us down to the first slide. So this is the agenda that we're going to be looking at today. So we are going to be looking at some of the challenges around returning to the workplace. As you can see, and as we saw my husband walking in, I'm working from home today. I think Vicky is based from home today as well, but we are also going into the office, and we'll talk about some of the challenges around that, and we'll also look at the workplace health and safety obligations. Something that's come up that has been quite interesting is the issue around vaccination status, whether or not you can have a no jab, no job, bit of a Daily Mail headline. And then what we're going to do is look at some interesting cases that have come out of COVID-19, which focus on discrimination, and particularly pregnancy, disability and discrimination by association, which are quite interesting cases anyway. You don't get that many associative discrimination cases. And then we're going to look at cases that look at reasonable management instructions, which again, you don't often get that many cases where people are told to do something, they don't do it, and then they get dismissed. So it's quite a nice sort of reminder about that. We're going to also look at some automatically unfair dismissal and health and safety concerns, and then we're going to have a Q&A session. So if there are questions that you have that you want to ask as we go along, pop them in the Q&A box, but I probably won't deal with them until we get to the end of the presentation, just because it can be a little bit distracting in that I'm not good at multitasking, although I am a woman. I can get easily sidetracked, and before you know it, we're an hour and a half down the line and I've not actually done any of the presentation that I'm here to do. So first of all, we're going to look at returning to the workplace and health and safety. And if we just go to the next slide. So all of us will be familiar with the government's announcement back in March. God, it seems like an age ago now, doesn't it? Those days back in March, where Boris Johnson came on the television and told us all that where we could, we all had to work from home. And that became very much what we were required to do in jobs where you could work from home. And so not many people were in offices. I know that there were some people going back to work during the summer last year, but then I think with the different lockdowns back at the end of last year and then at the beginning of this year, sort of the working from home became the default position, and that's certainly what the government guidance was. Obviously, since then, we've had the vaccination programme, and the government, as a result of that, published their roadmap. And so that was published in July this year. One of the steps was in July that the lockdown rules and regulations were to be removed and replaced with advisory guidance to businesses and individuals. And then from the 19th of July, step 4 was implemented. And things like, which meant that people could return to the office. Now, even though the government had published that guidance, it didn't necessarily mean that employers had to get people back into work, or that indeed there was a massive appetite for people to go back into the workplace. So there was a lot of guidance around social distancing and around health and safety risk assessments, which we'll come on to have a look at later. But if we just move on to the next slide, please, Emma. As of July, all social distancing restrictions were removed, and businesses and workplaces, actually that was August, businesses and workplaces could open without any limits on attendance or social distancing. Now, interestingly, what we have done as a business is looked at the guidance, looked at our risk assessments, looked at our buildings, and we have kept it under review, and we have quite clear guidance about the number of people that are permitted in the building at any one time. So at one point we were looking at a third of our workforce being allowed in. That went up slowly, and I think we're now at 75%. But interestingly, today I've got colleagues who are in the office and some haven't been permitted to go in because we're over that limit. So we've got quite clear rules about when you're allowed in and when you're not allowed in. And I'm sure that all of your organisations have got similar provisions in place to ensure that as far as possible you can ensure the health and safety of your workforce. I don't know what that is. So as part of all of this process, Emma, if you'd like to move on to the next slide, please. The government have provided guidance for employers, and they've published guidance for different sectors. So there is a construction one, there's obviously an office one, and each one has guidance around what you should be doing to reduce the risk in the workplace as much as possible. And there'll be lots of risk assessments that your employers would have been looking at. And what the guidance says is that employers should take account of this guidance in preparing risk assessments. So you'll probably notice that there's lots of hand sanitizers around, that there's guidance probably still around social distancing, although I've noticed in our office particularly that some of that has now been lifted in response to the revised guidance. But there's definitely, as I say, lots of hand sanitizer, lots of signs encouraging people to wash their hands regularly, and also we've got the wipe things for workstations. So, and I'm sure all of you are now familiar with all of that as well. So, if we just pause there. Actually, I'm just trying to work out which slide we're on, Emma. Do you want to give me a clue?
I can't see the slide. I can't see what numbers they are, I'm afraid, because it takes over my entire screen.
Yeah, exactly. Okay, so one of the issues that we've had around COVID is how do we deal with people who are considered to be clinically extremely vulnerable? And people, you'll recall way back when, those who were considered as being clinically extremely vulnerable were notified of their status, and they were advised to take additional measures to those that the general population was required to take, including not going into a workplace, not going into public spaces and that kind of thing. And obviously we had to be extremely careful about what we were asking and what we were not asking those people to do. Shielding though was paused on 31st of March this year. Nevertheless, I think the approach that we take is that even where people are obviously not being required to shield anymore, they are going to be extremely concerned about coming back into the workplace, and they will want to take a more cautious approach. It's likely, isn't it, that if somebody is considered as clinically extremely vulnerable, it may well be that they have a disability within the meaning of the Equality Act. And certainly the questions and types of queries that we've had from clients is that we have, in circumstances where they are considered disabled, we have advised that you might want to think about continuing to allow them to remain at work, working from home where they can, because that's probably going to amount to a reasonable adjustment. And we'll come on and have a look at health and safety and the protection that you get for raising health and safety concerns at work a bit later, but that's something just to think about. I think now's quite a good time, Emma, to do the first poll. So one of the things that we have is whether or not people are struggling, and whether they are requesting to remain working from home. So if you have employees who are considered clinically extremely vulnerable and are requesting to remain working from home, can you just click on yes or no, just so we can get a view of whether or not this is an issue for you? Yeah, that's not a surprise, is it? Speaking from just on the clients that we've advised, it's quite difficult, isn't it, to try and get those people back into the workplace where they are feeling vulnerable. And it may well be that it's a gradual thing, that you can continue to work with them. I've certainly tried to meet with some of my colleagues in settings where they feel a bit more comfortable. So outside, we've gone for a walk, just to try and make them feel that they're part of something and they're not feeling excluded. But in terms of the workplace itself, I still think that there's probably a little way to go with that. So as I just said, that the government's advice is that you're no longer necessary to instruct people to work from home, and I'm pretty sure that employers are quite a long way down the road in terms of asking people to return to the workforce. Now we are looking at returning 2 days a week. It'll probably go up to 3 days a week, I would imagine, in due course, for full-time staff. But there's no requirement for everybody to be back in the office all the time. So, and I'd imagine that's probably the same for most of you as well. If we can move on to the next slide. So what is going to happen going forward? Can employers insist on employees coming back to the office? And what does a COVID-19 safe office look like? Well, it looks quite quiet, is what I can gather from our office. Lots of people spread out. We have configured the offices in a way so that there is more space between individuals, which makes sense. Interestingly, a recent survey has shown that 68% of employees are worried about contracting COVID-19 when they return to work. And I think that's a combination of contracting it in the workplace, but also contracting it in terms of how you get into the office, and whether you're at greater risk if you're using public transport, for example. So what we advise is that you keep a very open dialogue with your workforce in terms of putting all of the measures in place and explaining to people what you're doing in order to keep them safe as far as possible. It's obviously you need to listen to your employees and understand what their concerns are about coming back to the office, and it is lots of different things. As I say, some of it is around travelling into the office, some of it is being too close to other people, but it's really helpful, I think, to talk those through and just encourage people gently at the start of it, as we sort of go back into something like normal, whatever normal looks like now. There is, of course, a possibility that people will never go back to a full return to the office, and I think we think that now, but it's going to be very interesting to see what happens in a year's time, maybe 2 years' time, and whether or not working from home will be a distant memory. I'm not sure that it will be, but it's going to be very interesting, I think. So what is the future of working from home, and what are some of the issues that we need to think about? So some employers have already shifted to a remote or hybrid model for the long term. Interestingly, I did a webinar for another section of clients yesterday, and some of the queries that we were getting were, we've already agreed with a section of the workforce that they are permanently working from home, but we've got a bit of a problem now in that we've got another section of the workforce who's saying that they want to work from home all the time, and because we've already agreed with another section of the workforce, it's not tenable for the others to be treated the same. So that's a bit of a conundrum, isn't it, in terms of what you agree. And as things stand at the moment, there isn't an automatic right to work from home, and I do think that because of the government's announcement last year, there is a bit of an assumption that everyone can just work from home now, and that's what we're going to do, and I've got this almost like this legal right to do it, and that's just not the case at all. You do have a right to make a request to work flexibly under the flexible working request regime, and currently you have that where you've got 26 weeks continuous service, and of course a flexible working request can cover all sorts of things, can't it? It can cover working from home all the time or some of the time. It can be a variation in your hours or your days of work, as you probably know, an employer's got the duty to consider those flexible working requests, and in circumstances, and consider them reasonably and in a reasonable manner. And in circumstances where you wish to, or you feel that you can't agree to that working request, you can refuse it based on the 8 permitted reasons. Basically, these are, for those of you who are not terribly familiar with them, they are where there is a burden on the business of additional costs, where you think that it will have a detrimental effect on your ability to meet customer demand, an inability to reorganise work amongst other employees, an inability to recruit additional employees, a detrimental effect on quality, detrimental effect on performance, insufficient work at times when the employee proposes to work, and planned structural changes. Now, usually there aren't that many situations where you can't you can't fit a request into that. I'm being very negative, I know, but that it's unusual where you can't fit a refusal into one of those 8 reasons. But what I would say is that you can't just sort of slap one of those reasons onto a refusal. You need to have considered it properly, and you need to have considered it reasonably, and that's what the regulations require you to do. And certainly where you have issues around, for example, childcare commitments, where you haven't considered it properly and looked at all of the alternatives, you do run the risk that the individual could bring a claim for indirect sex discrimination. And the reason why it's indirect sex discrimination is because your practice criterion or provision, so the provision that an individual works full-time, is less able to be complied with or less able to be fulfilled by somebody with childcare commitments. And unless you can objectively justify it, then that could amount to indirect sex discrimination. So that's just an example of that. Now, interestingly, the government have, I think it was last week or the week before, announced a consultation on flexible working. There are a number of proposals or a number of issues to consult on. One was to make it a day one right, so you don't have to have 26 weeks continuous service in order to make a flexible working request. One of the proposals is to get rid of the 8 business reasons permitted by the regulations at the moment for refusing a request. And there were a couple of others, but all within that sort of same vein. Now, I can't imagine that all of that is likely to make its way through into legislation. I certainly can't imagine the business community necessarily thinking that getting rid of any reason to refuse flexible working is a good idea, because it means that they just can't plan their workflow properly. And what's also interesting is this week, obviously it's a Conservative conference, and I think it was over today, Thursday, Wednesday, Tuesday, there was a Boris Johnson soundbite which basically said, you need to get back into the office, you need to get back to work, people of this country, because if you don't, you run the risk of missing out on potential career progression. And also you miss out on office gossip, which I thought was quite funny. Now, gossip in this context can be opportunities, different things going on in the workplace that if you're not there, you may well miss out on, and therefore you miss out on opportunities. And I suppose gossip in the normal sense of the word, in that you're not getting to catch up with friends and colleagues in the normal way, even though we've got very used to doing things remotely now. I think there's something in that in both respects. I don't really agree with much that Boris Johnson says, but I do think that there is something in that. But it does seem to contradict the government's consultation on flexible working, and also the government's task force on flexible working, which is very much of the view that flexible working is a very good thing, which I again agree with, and therefore should almost be a bit of a default position rather than the rules that we've got at the moment. Also, just to finish that point of the chairman of the Conservative Party was heard to say that all civil servants should get back to the office, should get off their Peloton bikes, is what he said, and get back to the office, which again I thought was very funny. But again, completely contradicts the government consultation on flexible working and working from home. So I think it's a question of watch this space. We'll certainly be looking at it and reporting on it as it goes along. So if we can move on to the next slide. I've got a repetition there. Sorry, Emma, that's my fault. If we move on to the next one. Okay, so we've got people coming back into the workplace. They are slightly reluctant. I think probably now would be a good point to do the other poll, Emma. So we've obviously talked about people who are clinically extremely vulnerable, but in general terms, is there a reluctance in your workplace for people to come back? That would be really interesting to understand from those who are online. Just have a look at the rest. 67%. Now that's really interesting. I thought it might have been a little bit higher than that. I think that there's a reluctance on a number of levels. Obviously, there's the health and safety issue, isn't there, around the coronavirus. I think a lot of people have found an extra hour, an extra 2 hours in their day because they're not having to commute. People can be a bit more flexible about how and where and when they do their work, so they can sort of fit it around their domestic life a bit more. And I think probably people are reluctant to go back to the old way of working. You know, that very rigid in the office till 6 o'clock or whatever, and then coming back. So interesting. So in terms of people coming back into the office, what are the employer's duties? Well, much of it depends on the nature of their work. I'm just scrolling down to my notes. As a general point, all employers have the duty to take reasonable steps to ensure the health and safety of their workforce. And this includes the provision of information, the provision of instruction, training and supervision, and extends to risks arising from the nature of the work, how the employer conducts its business, any supervision, training or instruction or any lack thereof, obviously plant, equipment, materials and substances used, conditions and provision of welfare benefits. And so these are all the sorts of things that you've had to take into account when looking at getting people back into the workplace. What do we have to do so far as reasonably practicable to ensure the health and safety and the welfare of employees? And some of it is around, for me, some of it is around communicating that to staff. So a lot of people will say, well, I'm scared about coming into work, I'm worried about it. And it's about explaining what you as an employer have done, taking into account all of the guidance that's available from the government in relation to coronavirus in getting them back into the workplace. So practical health and safety steps. Emma, if you'd like to move on. So what are the practical health and safety steps that an employer should take? Well, it's the duty of every employer to take reasonable steps to eliminate identified risks. And so as a minimum, you need to identify what could cause injury or illness in the workplace. Excuse me, I'm being asked to attend another meeting. This is the problem with being online, isn't it? Right, let me just decline that. Consulting with staff, that is one of the duties that you have as an employer, is to go to your staff and say, look, this is what we're planning on doing, what do you think? And it will give them an opportunity to come back and say, well, this is my concern, I think we should do this. And always, as we know with health and safety, it's about listening to what employees say, because they may well have some really good ideas that perhaps haven't been considered. You don't have a, and it's impossible, isn't it, to eliminate all risk in every situation. And what the law requires you to do is to take all reasonable steps. So understanding that everything that we do in life presents a risk. So going to work, getting in your car, getting on the bus, getting on the train, there is a risk there. And it's what is, I suppose, an acceptable level of risk, and ensuring that we've done all that we can do to minimise as far as possible what the risk is. Things to consider is the cost and physical difficulty of taking measures to avoid or reduce that risk. And then, of course, people can report any failure to the health and safety executive or the local authority, so yourselves, where there may well be a risk that somebody has flagged up and that the employer is not taken into account. But a thorough and a well thought out risk assessment is obviously the thing to do to ensure that you can evidence and you've thought through everything in terms of ensuring that it's a safe place of work. One thing that has cropped up is whether or not if you have coronavirus cases within your workplace, whether or not you have to report that under the RIDDOR regime. And the answer is it's not very clear, and it remains a bit of a disputed area. So you've probably got health and safety officers in your organised, well, I know that you do, who will be looking at this. The additional steps that you might want to take place, we've all become, experts in hygiene and hand washing, so additional steps are making sure that hygiene is promoted, that there is ample hand sanitizer, that people are reminded regularly to wash their hands. The other thing is about adequate ventilation. We have a bit of an issue in our Bristol office in that we can't open any of the windows because it's a WYSI air-conditioned building, which is not ideal when you're looking at encouraging ventilation. But in buildings where you don't have that, then obviously lots of doors open, lots of windows open. And then communicating with people who may well be considered as vulnerable, and trying to give them the reassurance where possible, and continue working from home where you can. Right, the next thing I want to talk about is vaccination. And again, this is probably a good place to start in terms, before we get on to vaccination, is to just do a quick poll around whether or not you as an employer have, or whether your organisation has a vaccination policy or is considering a vaccination policy. 50-50. Very interesting. I think that probably reflects some differing approaches around vaccination generally, doesn't it? And how people feel about vaccination. Although I think the statistics are that more people are in favour of vaccination than are not. But not necessarily when it comes into the workplace. Right, let's move on to the next slide, Emma. We're going to look at vaccination status. So, from an employee's perspective, there is lots of guidance around vaccination and vaccinated employees. And there's some really good guidance produced by by Public Health England. ACAS have produced guidance, and there is guidance from EHRC around how this could impact on, or how it could be discriminatory. But basically what the PHE and what ACAS talk about is for an employer to encourage employees to have the vaccine and to promote the benefits of a vaccinated workforce and a vaccinated population, but doing so in a way where staff aren't required to have the vaccination. So if that is their choice for, in the whole variety of reasons why people may not want to be vaccinated, but there are ways of encouraging. So some employers are offering for employees to have paid time off to attend vaccination appointments. So there can't be any concerns around missing work and perhaps not being paid for the time that they miss work when they have vaccination. But some of the guidance from the PHE is about having departmental champions, about signposting, facilitating, as I say, time off, and looking to amend policies. What you can't do is obviously force an employee to be vaccinated without their consent, because obviously that would be assault. What you need to think about is any any mandatory or blanket policies around vaccination. So again, it would be difficult in most workplaces, but not all, to have a requirement that an individual, in order to be able to come into the workplace, is vaccinated. So you need to think quite carefully about why it is that you require them to be vaccinated, and whether or not that is actually a true requirement. So for somebody like me who sits in an office and sits in front of a computer screen all day, there's nothing inherent in my role that requires me to be vaccinated. Yes, in the broader sense, it's a good thing to have in that it provides me with personal protection and looks at reducing the risks to me and the broader population, but there's nothing inherent in my role that requires me to be vaccinated. I hope that makes sense. Also, what Public Health England also say is that it's to encourage people to have the vaccination is part of the employer's responsibility to reduce workplace infection. Now, there's a lot of talk, isn't there, about the extent to which vaccinated people don't spread, or the spread of COVID is reduced. I'm not quite sure where we are on that, but that's certainly what the PHE are saying. In terms of having blanket policies, obviously, you need to think very carefully about it, because there will be individuals who won't be able to get vaccinated, and we'll look at some of the risks associated with that in a moment. Emma, could we just move on to the next slide, please? So, can you ask employees about their vaccine status? Can you say to them, well, you're coming into the workplace, you'll be coming into contact with lots of different people. For example, maybe you're a teacher, that kind of thing. Can you ask about the vaccine status? So you can ask, but you need a good reason to know. For example, the health and safety of other employees. And you do need to think very carefully, and I'm not an expert on this, so Vicky will may well be able to add to this, but this sort of information is classified as personal sensitive health information, and therefore in terms of how you store that information, you need to think very carefully about where that is stored, just to make sure that you comply with data protection legislation. But if somebody doesn't tell you what their vaccination status is, because frankly it's none of your business, for example, what can you actually do with that? Well, probably, unless there is a specific reason for needing that information, probably nothing. Again, if somebody asks me, I'm quite happy to tell somebody what my vaccination status is, but it's not really relevant for my role, and I can certainly see circumstances where people would not want to disclose that information. But what the ICO say, and I'm sure Vicky will be able to jump in and tell me where I'm going wrong here, but asking employees to tell you about their vaccination status is less risky than insisting that they do so, because you're less likely to make a data protection complaint, and the ICO would be more likely to regard your policy as proportionate if there's no mandatory element to it. So I can ask you, you're not required to tell me if you don't want to, and there'll be no consequences of doing it. But again, think carefully about why you want that information in the first place. So the ICO has published advice to organisations who are collecting vaccination status, which confirms that collection of data must be necessary and relevant for a specific purpose. However, it does confirm that if there is a good reason for collecting the information, there is a lawful basis to process this data. So I think you do need to think quite carefully about just what I said earlier, what is it about that person and that role that requires you to know that information, and therefore hold the information and process it. So again, in terms of refusal, if employees refuse to answer, you can get yourself into a bit of difficulty if you start relying on a refusal to obey a reasonable management instruction. And as I said at the beginning of this session, those sorts of principles are quite basic bits and pieces of sort of unfair dismissal legislation that you don't normally come across. But we now are, because obviously we're asking people to work in different ways and do different things, and these sorts of issues are cropping up again. We have obviously had the certification issues that the government have introduced, and the NHS COVID pass, but we don't appear to be having those now. Although I did see, I'm not sure if any of our attendees today are from Wales, but I did see that the Welsh government are introducing COVID passes. So, and I think Scotland have done the same. I'm not quite sure whether that covers the workplace, but presumably people who work in situations where there's lots of people will be required to do it. I just want to mention quickly, because you're probably all thinking, yeah, but what about healthcare workers, people working in nursing homes? That has now been mandatory, so you do have to be vaccinated from this month to be able to work in those settings. And I think, again, we'll come on to it a bit later, but it will be very interesting to see whether the government extend that to other sort of settings in a broader way, because at the moment that's quite, well, it's significant, but it's much smaller than perhaps requiring everybody working in the NHS, for example. And obviously some of that comes around because of the disproportionate way that COVID affected more vulnerable people and people residing in nursing homes. Okay, let's go on to the next slide. So what about at the recruitment stage? Can you ask candidates if they are fully vaccinated? Generally, information around health is not permitted to be asked at interview stage. Certainly we wouldn't ask somebody if they've got any disabilities unless it was relevant for the role, because that could impact on your decision to recruit them for that role or not. So you would need to again think why you would be wanting to do that. And Section 60 of the Equality Act is a bit of legislation that restricts you from doing that. And it is thought that actually asking people their vaccination status it's not been tested yet, but it could be a breach of Section 60. So you need to think about whether or not that is essential for the job. And obviously if it's a nursing home setting where it's now mandatory, then you might want to think about that. But we'll consider this again going forward. If we can just move on to the next slide. So what about no jab, no job? For those of you who have been keeping up with the media, no jab, no job became quite a hot topic over the summer, didn't it? There is a quite an in employment circles, he's quite well known because he challenges lots of employment legislation. Sorry, if we can go on the next slide, Emma. His name is Charlie Mullins, and he is the owner and chairman of Pimlico Plumbers, who are a large plumbing firm. And he said, and I think his words were, it's a no-brainer. Of course, all employees should be vaccinated. They're going into people's homes and carrying out, you know, building works and obviously mainly plumbing works. You know, if you don't get a jab, then you don't have a job with me. He rode back from that slightly because obviously he took advice which meant that he understood that there were some legal constraints to doing what he wanted to do. And I'll just go on to talk about those in a minute. But in February this year, Nadhim Zahawi, who was then the COVID vaccine rollout minister, stated that it's up to businesses to decide whether to require staff to be inoculated against the virus. But the Labour Party came back and said, well, actually, no jab, no job may leave workers exposed to unlawful discrimination, and that's probably where we get to with it. There, at the moment, so as an employee, there's no requirement for you in your role to be vaccinated against COVID in order for you to perform your role. So if there's now a requirement, you would have to get the individual's consent, which would amount to a change in their contract of employment. And as we all know, in order to get a change to a contract, you'd need their consent. And if they have issues about being vaccinated, then they're not going to give it. So you need to, again, you need to think quite carefully about what you're then going to do. Are you then going to say to them, well, you can't work here if you've not been vaccinated, if it's a role that's not where being vaccinated isn't necessary. So I think we're going back to Mr. Mullins. I think where he got to is that he then sort of changed tack slightly and said, well, for all new applicants, there is a requirement that they are vaccinated. And the reason that I need that is that some of our clients are vulnerable, they're older, and we want to be able to give them the peace of mind that all of our workforce are fully vaccinated against COVID. So if we move on to the next slide. So that slide just sort of repeats really what I've just said. In terms of requiring people, there is a discrimination issue around potentially age, race, religion, and disability. And I will come on to look at those in a moment. So if we just go on to the next slide, I'm just going into a bit more detail about compulsory vaccinated in care homes. So the new legislation means that from this month, anyone working in a registered care home must have 2 doses of the COVID-19 vaccine unless they have medical exemptions. It is subject to parliamentary approval and is going through, I think, at the moment. But it is intended to apply only to those in a CQC registered care home and will apply to all of the following workers. So all workers employed directly by the care home or care home provider, those employed by an agency and deployed by the care home, and volunteers deployed in the care home. So at the moment, there doesn't appear to be any plans to extend mandatory vaccinations, but there is a consultation on looking at whether or not to make COVID-19 and flu vaccination a condition of employment in health and care settings, where extending this policy beyond care homes. So it could be other people coming into care homes as well. So I think, again, it's one of those things that we'll just have to keep an eye on in terms of how it could be rolled out a bit further than just the care home setting at the moment. If we can just move on to the next slide. So what are the potential risks? So I sort of flagged up some of the risks around individuals who might not be able to or may not be having vaccination, and that may be people who have immune system disorders and so will not be able to comply with the requirements. Those who are pregnant may feel less inclined to have the vaccination at the moment, although the vaccination has, we're told, not been shown to be have any kind of adverse effect on the baby or the mother. But again, it's understandable, isn't it, that people might be reluctant to have what is ultimately a fairly new vaccine when they're pregnant. People who have long COVID may need to defer vaccination in those circumstances. Some people have ethical concerns about how the vaccine has been manufactured and requirement to have the vaccine, and some people may well have religious issues around, or the vaccine may in some way not be in line with their religious belief. So if we just go on to the next page, we're just going to have a bit more detailed look at the risks. So the possible claims could be for indirect discrimination around age. Probably this one has gone a little bit because originally when the vaccine rollout came out, obviously it was those who were considered clinically extremely vulnerable and those who were older who were offered the vaccine the first time around. So younger employees, and I count myself in one of those categories for a little while until the vaccine rollout caught me up, were less likely to be able to comply because obviously they weren't being given the vaccine at the same time as older people. Also, younger workers may be cautious of being vaccinated due to their lower risk of hospitalisation. And there was some commentary earlier in the year, wasn't there, around younger people being more at risk from suffering from side effects from the vaccine, so blood clots and so on. So they may be less able to comply as well, which obviously brings into focus an indirect age claim. Obviously, disability, we've touched on that, haven't we, with people who potentially have suppressed immune systems. Some people might have certain allergies and may have been advised not to have the vaccine. There may be mental health reasons, and some people have a phobia of needles, which means that they are less likely to be able to have the vaccine. Pregnancy and maternity we've touched on. Some people may want to delay having the vaccination because they're actively trying to conceive, and some people have got concerns over the effect of the vaccination on that. Although again, what I would say is that the evidence is that it doesn't have an impact on fertility. I'm only going on what the guidance says. It's not a personal opinion in any way. And then race, there has been a lower take up in areas where there is a high proportion of people from an ethnic minority. And so again, the guidance is saying that people from those groups are more hesitant in having the vaccine, so are less likely to have been vaccinated. And then again, in terms of religion or belief, it's possible that protected characteristics of religious or philosophical belief could protect individuals where they have a religious or moral objection to the vaccine. So you can see, can't you, quite clearly that any detrimental impact in terms of people refusing to have the vaccine for one of those reasons, you could end up with a fairly significant discrimination claim on your hands. Okay, we go to the next slide. Let's crack on with where we are with COVID-19 cases. So let me just scroll down. So I have to say that COVID has been a real steep learning curve for employment lawyers. We had to very, very quickly get up to speed with a completely new concept called furlough that required us to do a lot of thinking about how furlough impacted on the contract of employment, how it was going to be paid, the fact that it amounted to variation of contract of employment, how holiday accrued during periods of furlough, and so on and so forth. And obviously the government guidance changed weekly, usually on a Friday afternoon. So it was interesting. And then also what we found was that we were having to get to grips with legislation that as an employment lawyer you don't often have to look at, and all of a sudden, and there wasn't much case law on either. And all of a sudden we were having to be experts and think about health and safety legislation and how people raising concerns around health and safety in the COVID-19 context could, what kind of risk that could give to an employer. So we'll look at that a bit later, but this first case involved a lady called Mrs. Prosser, and she worked for a company called Community Gateway Limited. Mrs. Prosser, or Ms. Prosser, was a pregnant 0 hours worker, and she was pregnant. And at the start of the pandemic, her employer, Community Gateway, considered that she was clinically vulnerable because of her pregnant status, her status as a pregnant employee. She was quite keen to return to the workplace, and that was delayed on a number of occasions because the employer was having to conduct risk assessments, and obviously they had to think particularly about her and the risk assessment around her. They also needed to implement social distancing measures, and that meant, you know, the practical things that we've all come to know and love, you know, reorganizing desks, spacing stuff out, purchasing perspex screens, which, like a lot of things at the start of the pandemic, were in short supply and difficult to get hold of, and so that delayed things. And so she was frustrated by that and wasn't able to come back. She was also told that when she did come back, she was asked not to undertake night shifts, which night shifts were normally undertaken as a lone worker, and you would be required to travel unaccompanied to tenants' homes for the provision of physical support, and it was deemed that in circumstances this was unsafe for her as a pregnant worker. So she wasn't subjected to any kind of detriment in terms of how much she was paid. In fact, the company had been very generous and had paid her in excess of her contractual entitlement, and wasn't, it says, out of pocket. There was one instance where she was paid late, but that wasn't because of her status as a pregnant worker. That was an administrative error. So she brought a claim for discrimination and victimisation. So she said that she'd been treated less favourably because of her pregnancy, and that she'd been victimised as well. And what the tribunal basically disagreed with that and dismissed her claim, and said that her treatment was appropriately informed by the appropriate public health advice and the relevant COVID regulations at the time. And a formal risk assessment had been undertaken and had been completed by the employer, and at all times the employer's motive was to protect her and her unborn baby, and so there was no discrimination. So it's an interesting one, isn't it? Because obviously this lady was keen to get back into the workplace. The employer took a very protective view of her, and did all that they should have done in terms of protecting her health and safety. And it wasn't motivated in any way by her pregnancy and treating her differently, or subjecting her to a detriment because of her pregnancy. So we certainly had lots of calls around pregnant workers during the pandemic and how to treat them, and the risk factors associated with them. So I don't think that case comes as a huge surprise, to be honest. If we move on to the next case, this is quite an interesting one, because it sort of chimes with some of the things that we've been talking about around home working, and why people would want to continually work from home. So just finding the right case. This lady was employed by Nationwide as a senior lending manager, and she was a home worker. She was on a home worker contract, and part of the reason for that was that she was the main carer for her disabled mother. Nationwide wanted all senior lending managers to come into the office and undertake supervisory duties, but Mrs. Follows said, well, I can't do that because I have caregiving responsibilities for my mother. My mother is classed as disabled under the Equality Act, therefore I can't do that. And actually I've been doing my job well leading up to this, and there's no reason why I can't carry on doing my job in the same way that I have been, notwithstanding what you're saying about undertaking supervisory claims. So Mrs. Follows brought a number of claims, and the ET upheld her claim of indirect disability discrimination by association, so associative discrimination. So it wasn't Mrs. Follows's disability, it was the fact that she was subjected to discrimination because of her association with an individual who is disabled, i.e. her mother. What's interesting with this one is that some of the areas that we've been asked to advise on is where people have tried to get people back into the office and have said to them, you need to be coming back into the office because some of your role is around managing other people and carrying out supervision of other people, and therefore we need to bring you back in. And if you go on the rationale of this case, it would suggest that that isn't sufficient to be an objective justification for that sort of discrimination. And I know that certainly that is some of the justification for getting people back in, is that people aren't being adequate, or there's a perception that people aren't being adequately managed remotely. So I would think carefully when you're thinking about requiring people to come back in, and you are looking at the basis and the justification for doing that. And I suppose what I would say with all of these things around flexible working and home working and so on is that people, you need to treat everyone individually, and not one size is going to fit all, because everyone has their own their own set of circumstances, which mean that they're less able to comply with these sorts of requirements. So I think that's quite an interesting one. And as I said, it's something that we're coming across in terms of getting people being required to come back to the workplace. Emma, would you like to move on to the next one? So this is quite an interesting one. And it's a bit old school in terms of people not doing what they should be doing in their role, or being asked to do what they're doing. So Mr. Kubilius was, I'm not sure if I pronounced that correctly, but we'll go with it, was employed by Kent Foods, who is a delivery driver, and his role required him to follow work rules, and these were all contained in the staff handbook. And these rules included treating Kent Foods customers with courtesy, specifically stating that excuse me, rudeness or offhand treatment of clients will not be tolerated. He was obliged to take all reasonable steps to safeguard his own health and safety, and that of any other person who may be affected by his actions at work. And it stated that customer instruction regarding PPE requirements must be followed, meaning he should follow customer instructions regarding what PPE must be worn when visiting customer sites. So in May last year, Mr. Kubilius drove into the customer site of one of their clients, Tate and Lyle. And as a result of COVID, the customer required that face masks be worn by all visitors. And they were issued with a face mask when they arrived on site. Mr. Kubilius did not wear his face mask and was asked by two of the Tate and Lyle staff to wear masks whilst he was in the cab of his lorry. Now, the staff warned him of the potential health and contamination risks of not doing so, but he stated that it was not a legal requirement to wear a face mask in his own area, so in the cab of his lorry, and therefore he wasn't going to wear one. Tate and Lyle were unhappy about that, and you can understand why in the circumstances, and they reported the matter to his employer, Kent Foods, and they said, we don't want him on our site anymore. He's effectively banned from coming onto our site because of how he conducted himself. Kent Foods apparently conducted a very detailed investigation into this incident and invited Mr. Kubilius into a disciplinary hearing. The allegation he faced was that in refusing to comply with Tate and Lyle's instructions regarding PPE, he had breached the requirements to maintain a good relationship with clients and to cooperate to ensure a safe working environment. He was then dismissed without notice, and he then brought a claim for unfair dismissal. Unsurprisingly, I think, the Employment Tribunal found that his dismissal was in fact fair, and they found that Kent Foods had a genuine belief, following a reasonable investigation, which is what the test in unfair dismissal requires, and that he had been guilty of misconduct. So the investigation was fair and reasonable, and the reality of this situation was the facts were not really in dispute. I don't think it was in dispute that they'd asked him to wear a mask. He'd said he didn't want to wear a mask, and that was the end of that. And they found that Kent Foods had behaved reasonably in treating misconduct as a sufficient reason for dismissal. And what was interesting is that the employer had been entitled to take into account the importance of maintaining a good relationship with their client. And Mr. Kublius had never acknowledged any wrongdoing, which posed a risk for the future. So what they were saying is that he could go onto another site and be told something different, and we're not confident that he would do as he's told. And I suppose that's particularly relevant when you're looking at health and safety, and when you're looking at what the COVID rules are for going onto other people's sites, and that their employees need to respect that. So that was a fair dismissal. Can we go on to the next slide, please, Emma? Okay, so this is another interesting one with Mr. Ham. Sorry, I'm just getting to my notes, bear with me. Never find it when you want it, can you? So Mr. Ham was employed by BBSW, and he was a cleaner, and he was asked to deliver, and this was right at the beginning of the pandemic, so I think you need to sort of see it in the context in which it happened. And he'd been asked to go around to his manager's house and drop off some cleaning equipment. And ordinarily that would have been fine, but his manager had informed him that he was at home isolating because he had COVID-19 symptoms, as did his daughter. Now, unsurprisingly, Mr. Ham was a bit reluctant to put himself in that position where he would be confronted by somebody who potentially could have had COVID. And again, if you look back at where we were in March, April, May last year, no one really understood, or the understanding around how at risk he may or may not have been wasn't as well understood as it perhaps is now. And so he refused, citing health and safety concerns. And also he did come forward and say, look, I'm happy to drop the equipment off somewhere else, and you could go and pick it up then when you feel well enough to do so. And then you've got what you need, and I feel that I'm not putting myself at risk by doing that. But he was dismissed as a consequence of taking the step that he did. And the tribunal found that his dismissal was automatically unfair. And the reason why it was automatically unfair is because he was dismissed for basically making a concern known about health and safety, and that's one of the reasons for a dismissal being automatically unfair rather than substantively unfair. He probably didn't have sufficient service to qualify for a claim for unfair dismissal. But it's surprising that his employer took the stance that it did in those circumstances, where you've got somebody who's at home isolating and requiring somebody to potentially come into contact with somebody. I'm sure there's probably other things going on there that led to this, but that was the finding of the tribunal in that situation. Could you move on to the next slide? So health and safety cases now. So if we can go on to the next slide. So this is what I was talking about earlier when I said all of a sudden we were having to look at section 44 and section 100 of the Employment Rights Act, which you don't often have to look at. But section 44 is about situations where somebody makes disclosures around safe working arrangements, unsafe workplace, could bring a claim for constructive dismissal for raising one of those. And section 100 provides this automatic unfair dismissal bit in circumstances where they've either left the workplace, refused to work, or took self-protection measures in circumstances of imminent danger. So if you've dismissed somebody because of those three reasons, then that dismissal will be automatically unfair. And there isn't much case law on this. So again, we were having lots of Zoom calls and team calls as a team to just work through some of the scenarios that may come about as a result of COVID. And unsurprisingly, they found themselves in case loss. We're just going to have a quick look at some of those cases. Sam, if you can move on. Okay, so the next case that we're going to look at is a case called Rogers and Leeds Laser Cutting Limited. And Mr. Rogers messaged his manager to say at the beginning of the pandemic that he would be staying away from his workplace until the lockdown had eased, because he was worried excuse me, about infecting his vulnerable children. So he had a baby and a child with sickle cell anemia. He didn't go back to the workplace, and a month later he was dismissed, but he brought claims under section 101D and E of the Employment Rights Act. And the reason in the Employment Tribunal, when you looked at what actually happened, the Employment Tribunal said that his evidence was vague and contradictory, but it did accept that he worked in a very large warehouse type space, which typically included only 5 workers at the relevant time, and in respect of which the employer had already taken measures to limit the risk of exposure of COVID-19. So what they're saying is actually your risk of contracting COVID-19 in the workplace was very low. You work in a well-ventilated building. There's not that many people there at any one time. And in addition to that, the employer had taken other measures to, where possible, reduce the risk of COVID-19. Interestingly, in its concluding remarks, I think this is interesting in terms of COVID-19 and the bit in the legislation which talks about imminent danger. It says that, interestingly, in its concluding remarks, the Employment Tribunal rejected submissions that the relevant provisions of the Employment Rights Act could not apply to situations arising from the COVID pandemic, but did not accept that the existence of COVID-19 creates circumstances of serious and imminent danger which cannot be averted regardless of the employer's safety precautions. So basically they're saying that COVID-19 of itself cannot be a serious and imminent danger because of the safety precautions that you can put in place to reduce the risk as much as possible. The decision was that he was fairly dismissed, and a reasonable belief in a serious and imminent workplace danger was not established. The evidence did not demonstrate that Mr. Rogers' decision to stay away from his workplace was directly linked to concerns regarding the workplace. He wasn't helped by the fact that there was evidence that he had taken somebody to the hospital in his own car, and that he had been to the pub and spent a period working in the pub. So if you had a serious concern, so Vicky's smiling, if you had a serious concern that there was an imminent and real danger of you contracting COVID in the workplace, you wouldn't reasonably behave in the way that he did. So that's some interesting evidence. It'd be interesting to know where they got that from. And so he lost his case, and it was found to be a fair dismissal. Could we move on to the next case, please? So this is another case, this is Gibson and Lothian Leisure, and in this case, Mrs. Gibson, Mr. Gibson rather, got the gender wrong, sorry, was a chef in a restaurant, and the restaurant was owned by Lothian Leisure. The restaurant closed in March 2020, and Mr. Gibson was put on furlough. In advance of the reopening of the restaurant, the employer told him that, we're able to open now, I'd like you to come back. And he raised health and safety concerns. Obviously, he didn't come back, and his employment was terminated. And in that case, the tribunal held that Mr. Gibson had been unfairly dismissed because he had taken steps to protect his father in what he believed to be circumstances of serious and imminent danger. I suspect what happened in that case is that he raised health and safety issues which weren't properly dealt with, and in the circumstances, his father was vulnerable, and he took reasonable steps because he believed that he could have been in serious and imminent danger. So another health and safety type case. And if we can move on to the next one. So Mr. Akatit, gosh, I'm not sure I'm going to be able to pronounce this one. Akatatis. Let's call him Mr. A because I can't get my teeth in. Mr. A worked for a company, interestingly, that made and distributed personal protective equipment. And if you recall, again, one of the other issues that we were dealing with at that time was a real shortage of PPE. Mr. A requested to work from home during the pandemic because he has some concerns around COVID, but his request was denied because his job required that he was physically present. And the evidence indicated that they were incredibly busy during this time. And therefore, the type of role that he did meant that he needed to be around. He did, in fact, contract COVID, or he had symptoms of COVID-19 and needed to self-isolate for a period of time. He then requested to be furloughed. That request was turned down because the company was really, really busy. And actually, really what the furlough scheme was for was to help and support companies where they had been adversely impacted by COVID and weren't able to trade. So a bit like the case before, where the restaurant was shut, or there was a decline in work because of COVID. He was then dismissed, in April, and he brought a claim for unfair dismissal. And the tribunal held that although Mr. A had a reasonable belief in the danger arising from COVID, he had not taken appropriate steps to protect himself or others from the virus. And that again would have looked at some of the other things that he probably was doing, which meant that, and that he wasn't engaging properly with his employer to look at the steps that they had taken to reduce the risk as far as possible. So quite an interesting one. I suppose quite ironic that he's working for a company making PPE in the circumstances. Have we got another case there, Emma? We do. Thought so. This one, I don't know about any of you, but we certainly had people and certainly had clients where during the pandemic at the very start, they got stuck in countries and were unable to get back. And in this case, Mr. Montanaro was on holiday in Italy when the country, so Italy, if you remember, went into lockdown earlier than we did. And he asked his employer for advice, instructions and assistance with documentation to get back. And he did actually actively take steps himself to work remotely from Italy. He didn't get any kind of response at all from his employer, but was dismissed, presumably on the basis that he wasn't back at work. And the tribunal held that Mr. Montanaro was automatically unfairly dismissed under Section 101E of the Employment Rights Act. There were clear circumstances of danger in that he was in Italy, which was itself in the grip of fairly difficult COVID-19. If you recall, they were the first ones in lockdown. I remember looking at them at work thinking, oh, that's nice, isn't it? They're all singing to each other on balconies whilst they're in lockdown. Isn't that nice? Until we found ourselves also in lockdown a few weeks later. Mr. Montanaro had been dismissed because he had communicated the difficulties posed by the pandemic, and that's found to be automatically unfair. I'm not sure if we've got one more case. I think we might have. No, we don't. So I'm just looking at the time. It's nearly quarter past 11, which is the time that I said I was going to hand over to Vicky. But I think we've got a few minutes if anyone's got any questions that they'd like to ask me via the chat box, the chat facility, or if anyone wants to put their camera and unmute themselves, they want to speak face to face, as it were.
I've got a question. Yeah, one of my questions relates to stuff about dealing with employees who are maybe, and I've got quite a mixed bag of employees. Some are actually really keen to get back into the office, and I find if I'm in the office, a lot of the more junior lawyers all choose to come in on when they know I'm going to be in the office, so there's a clear wish for that face-to-face supervision. But there's also people who are quite reluctant, and specifically one thing that's in my mind at the minute is in relation to, for instance, the SRA guidance that seems to be indicating that there should be a degree of face-to-face supervision. I think they've said minimum 2 days a week, and how that feeds in, one, in terms of people who are maybe reluctant to be back, and how much of a weight that can be given in terms of saying, well, look, but the guidance says you as a supervising solicitor ought to be providing this. But secondly, if our organisation, and I don't know where it will settle yet, if our organisation takes a different approach from, or maybe requires less presence in the office than the SRA seems to be indicating would be appropriate, and how you balance those different factors.
Yeah, it's difficult, isn't it? It depends as well, doesn't it? I must say I haven't read the SRA guidance, but I will do now. Is whether that supervision, that face-to-face supervision, whether what we're doing now is sufficient for that face-to-face supervision, or whether the guidance is sufficiently specific to require that to be in person rather than remotely. It sounds from what you're saying that it might be in person, and if that's right, then almost that's sort of the lever, isn't it, to say to people, actually, we need you to do this because it's actually a requirement of the SRA, and we wouldn't be in compliance if we didn't do it.
Yeah, and backed up by that is the fact that actually the juniors all seem to really want that, much more so than the supervising solicitors, that some of them don't have as good working setup anyway at home, or they genuinely feel that there's a practical gain from the supervision. But set against that, I know there's teams in the organisation that won't come back at all. So it's, it's team specific.
Yeah, I think the problem is that we've now got to a situation where a lot of people think that it is now, working from home is now the default position, where it isn't, because we're still in a transition period, and things are changing all the time, and the guidance from the government is changing. I totally echo your experience of the more junior people wanting to come back in because they can see the benefit of being with other people first and foremost, and the professional development of being back in the office with the supervisors. But I would definitely encourage greater attendance in the office and make it clear the reasons for doing so. Clearly, if somebody has, a bit like the Nationwide case, where the tribunal found that a requirement to come back in, potentially could be indirect discrimination or associated discrimination, where you've got somebody who themselves has a protected characteristic or a dependent who does, you might need to give that a bit more thought. But generally speaking, if you've got a business reason for them to be back in the office, which is to conduct, proper face-to-face supervision, then that's what they should be doing. I think you're right in what you say, that everything still is slightly uncertain as to what the longer term thinking of your organisation is going to be, and each of your authorities is going to be different, and I hear different things from different authorities about what they do, and even as you say, even department to department is different. But I think you can say that, look, we're still working through all of this, but these people need to be supervised properly. We're letting them down, aren't we, if we don't supervise them? That I feel that. Certainly in getting them back in, but I do wonder sometimes whether people do need to be reminded that working from home is not the default, and we're doing this at the moment because we're in the midst of a pandemic, and that things may change. but I know that people are taking quite a soft approach to it. I'm not sure if that helps, but
it's really helpful. It's that's the kind of swirl of factors, isn't it? But I think, like you say, that business need being demonstrated seems the most solid footing. Thank you.
I think so. That's all right, pleasure. Thanks. Does anyone else have a question? No? If you do think of something and but you're not happy to say it out loud, or you haven't quite thought of it, then by all means do drop us a line, and we'll try and pick it up and circulate it in an I can't speak today, in an anonymized way, and we'll circulate it to all of the attendees. But thank you very much for listening. It's been lovely to see you all again. Hopefully, fingers crossed, we can do it in person, and we may be able to welcome you back into our office. But in the meantime, I'll hand you over to Vicky. Thank you.
Thanks, Alison. Thanks. So we're not having a break. We're rushing straight into information governance, but I promise that I will pause in about 20 or 30 minutes so we can have another comfort break before we come back. But as with Alison, I'll pause it as we get to a point where it's hopefully we'll have a natural break. Could I have the next slide, please, Emma? Thanks. So these are the things that I'm going to be talking about today. I'm going to talk a little bit about COVID, so the UK GDPR implications of collecting vaccine information. So Alison has talked about the employment implications, but obviously it is personal data, so there are some data protection issues as well. Then I'm going to move on and talk about non-COVID things, which would be nice for a change. Subject to access requests and the effect of the first choice selection services decision. So there was an enforcement notice issued recently by the ICO in relation to a subject access request, and it's useful to sort of know where the ICO's tipping point is in terms of when they're not happy about compliance. A little health warning about out-of-date ICO guidance. Very briefly, a reminder about data sharing and contracts, when you need them, what you need and why. A brief update on the future of data protection in the UK. You may or may not be aware, but a consultation's just been released by the government on their proposals for a data something future. I can't remember what they call it, but I'll talk about some of the things that they're suggesting that might impact on local authorities, and why I think it's probably not going to go ahead anyway. And then finally, a brief update on FOI and EIR, so the environmental information regulations and freedom of information, a little bit on ICO decisions, and then some patterns and trends that I noticed in the sector. Here's the next slide, please, Emma. Thank you. So the data protection implications of collecting vaccine information. The first thing to say is that actually there's nothing in data protection law that stops you collecting information, and actually there's nothing in data protection law at all that stops you doing anything with personal data per se. It's just that you might have to jump through specific hoops before you can do what you want to do. So there's no bar to collecting the information, but you have to go about it the right way. And the key thing, and Alison said this earlier, you must have a valid reason for collecting it. So you can't collect it just because you think it might be interesting, or you'd quite like to just know how many people have and haven't, what sort of proportion, is it the same as the general population or anything like that. There must be an actual specific reason why you need that information. So we've had a few clients contact us in various sectors about this, and I had one recently from a theatre company who tour outside of the UK and outside of Europe. And so they were asking their performers whether or not they'd been vaccinated, because actually it was helpful for them to know that information, because if they were going on tour, they needed to know who was going to be allowed to fly, who would need to self-isolate either on the way out or the way back, or however it's going to work. And also at the point that they were asking me the question, there were issues around whether if their primary performer, the lead role, did contract COVID and had to self-isolate, how long would they have to self-isolate for because they hadn't been vaccinated, etc., etc. So they had a genuine reason for actually collecting this information. It was still voluntary to provide it, but they could explain why they wanted it. So once you know what your reason for asking is, you then have to make sure that your collection is fair, transparent, has a lawful basis, and you have a special condition. And this is the same analysis that you go through whenever you do anything with personal data. So fairness, I think that is actually quite a difficult question, because whether or not something is fair depends on what's a reasonable expectation of the individual. But I think the ICO takes a fairly pragmatic view. So again, as Alison said earlier, in my job, I don't think it's really necessary for my employer to know whether or not I've been vaccinated. In the context of the theatre company, it is a reasonable expectation. So depending on why you need the information, you may be able to mount an argument that actually it is fair in the circumstances. And I think if you've got a valid reason, automatically you can say actually then it is fair. It must be transparent. So you must have told everyone whose information you're collecting what you're collecting, information about whether or not they've been vaccinated, why you're collecting it, what your legal basis is, whether you're storing that information outside of Europe, all of the usual privacy notice information. What we've done for clients so far is produced a separate vaccine privacy notice. So it's much shorter, just deals with that specific type of information. And that's on the basis that at the time we were thinking this was possibly a time limited thing. So we weren't talking about boosters at the time. So it was just it was going to be a sort of one-off type collection of information. So it wouldn't be ongoing. So you didn't want, the organisations I was working with didn't want to make changes to their existing notices that would then be effectively irrelevant in 12 months' time. Whether that's still the case, I don't know, but you can do either. As long as you tell people, it doesn't matter whether you update your existing notices or you do a new one, however you want to do it is fine, as long as you do it. Then the lawful basis question, again, which lawful basis you pick depends upon the reason for which you're collecting it. In the case of, for example, care homes, where there's a legal requirement to be vaccinated, then you have a legal obligation to collect that information, so that's easy. Where you don't have that legal obligation, you might be able to fit it into something around health and safety, potentially, depending on the context of what it is you're actually doing, what information you're collecting and from whom. But it's more likely to be something around either public task or legitimate interests. And legitimate interest is usually the one that most organisations, certainly that I work with, are plumping for. And then you must have a special condition, because it is special category data, because it's information about health. So you have to not only have a lawful basis, you have to go through that second stage. And the one that the ICO suggests is public health. So you're collecting the information. And again, it depends on the reason you're collecting it for, because if you've got a clear legal obligation, you can rely on that. But if it is collection for the purposes of perhaps health and safety or organising your own sort of internal processes, then you may be able to rely on public health. If you are relying on that condition, you have to be able to show that the individuals who are collecting and who will have access to the information about whether or not someone has been vaccinated are under a duty of confidentiality that is equivalent to that of a medical professional. There is no actual duty of confidentiality specific to medical professionals. So there isn't actually a specific duty that I can point to and say, so they have to be subject to this specific regime or this specific statute. The duty of confidentiality that medical professionals are under is essentially that they do not disclose medical information unless required by law. They have the consent of the individual, and the duty of confidentiality extends beyond death. So personal data only applies to living individuals, but the duty of confidentiality extends beyond that. So what we have suggested is that if you are collecting the information and you want to hold it, and you need to demonstrate that the individuals have that duty of confidentiality, we've put together a very brief confidentiality agreement that you can get your employees to sign, and that covers you for that. Also, again, Alison's already mentioned this, check the security of the information. Where is it being stored? Who has access to it? Who needs access to it? Is it protected? How vulnerable is it, etc. And we also recommend carrying out a mini data protection impact assessment. So it's unlikely to be the type of processing for which you need to do a formal data protection impact assessment. So you don't need to go through that ridiculous form that the ICO has produced, but do a risk assessment. So, and it can be as simple as, why do we want the information? What are we using it for? What are the risks in collecting the information? What are the risks if we don't get the information? And how do we mitigate those risks? And that will show that you've given it some thought and gone through that process. Next slide, please. Thank you. So, subject access requests. And this is the enforcement notice that was issued against first choice selection services. So here we had a subject access request made in the context of employment proceedings. So nice and relevant and linked to what we've been talking about today. So an individual, I don't know what the employment proceedings were, it didn't say, but they were taking the employer to a tribunal and they made a subject access request. That happens all the time, and we all know that that happens. And in the past, we did have that really helpful case that said you weren't allowed to make a SAR if you were doing it, if you were already getting disclosure under employment proceedings. That's now bad law, it's been overturned, so you have to deal with the subject access request and the disclosure. So first choice selection services said, we're not giving you the information, we're going to disclose it as part of the employment process, so you're not having anything. And obviously the individual complained to the ICO. The ICO responded to FCSS and said, right, you must respond to this subject access request. And this is where it starts to get, you start to feel a bit less sympathetic towards FCSS and the eventual outcome, because they didn't do anything. And not only did they not do anything, they ignored 3 further letters from the ICO telling them to do something. And then they eventually do respond to the ICO, and they said that the tribunal had ordered that there be no release of records until the claims have been fully identified. They put this in a letter, but they didn't actually provide any evidence of this. So, of course, the data subject responded. They provided a record of the proceedings, which completely contradicted the FCSS claim. Now, I don't pretend to be an expert in employment tribunals, but even if a tribunal had made an order in that, in those sorts of terms, it would be about disclosure. It wouldn't be about subject access request. And because, as the tribunal actually said eventually, they'd actually have no jurisdiction over subject access requests, so they can't order a company not to comply with one. And the 2 processes are different. So as we all know, in tribunal proceedings, you have to disclose documents and there's a test of relevance. In subject access requests, you're disclosing information and there is no test of relevance. It's just whatever information the individual has asked you to release. So they are 2 entirely separate, actually, processes. The individual might get the same information as part of both, but they are separate and they are different. So data subject contradicts FCSS's claim. The ICO instructs the company to proceed with the SAR, and guess what? They didn't. So the ICO has now issued an enforcement notice, and the critical sort of part of that is, if FCSS don't comply with that enforcement notice, they could be hit with a fine. And I would imagine that the ICO is quite irritated by what's happened previously, particularly when you ignore letters from the ICO. So I also presume that they have complied, because we haven't had a fine issued, but I don't know how long those take. So, but that's the risk. So if you continually ignore subject access requests and you continually ignore the ICO, you could get a fine. Could we have the next slide, please? So the lessons to learn: respond to the ICO when they contact you. I would have thought that was common sense, but respond to your regulator. And I've already mentioned, subject access is a separate right to disclosure in the tribunal. Different rules apply, so you have to treat them differently. And if you are in this situation, my top tip is to think strategically. So it's not really a lesson from FCSS case, but actually, if you know that you're responding to a subject access request, you know the individual is about to or has issued tribunal proceedings, you know that they're going to get a copy of this email that you're not particularly happy about. Under subject access, you may be entitled to withhold that email because it's exempt under subject access. It's not exempt in the tribunal proceedings. You know they're going to get it anyway. So actually, is it better to disclose it now and then it's out there and it's done? Because it looks like you're trying to hide something if you don't give it now, but you end up giving it in the future. There may be good reasons why you still withhold it, and that's fine, but it is always worth thinking strategically. So not just going through the motions and applying the exemptions and not thinking about it. Think about it in the round. Have the next slide, please. So health warning about out-of-date ICO guidance. And this came up actually because a trainee did some research for me, and they came back and I read the research and I said, oh, I don't think that's right. And they said, oh no, it's fine because it's in the ICO guidance. And I went back and looked at the guidance. Oh, okay, that's out of date. So despite the fact that the GDPR has been in force for 3 years, and we had a further 2 years prior to that to prepare for it, there is still guidance on the ICO website that is pre-GDPR, so pre-2016, under the old regime. It does carry a health warning, so it does say on it, this guidance is under the previous regime, so you can rely on it, but you can't. It's a bit of a Boris Johnson go out, stay home type warning. So there is a health warning on it, but if you are looking at that guidance, please do double and triple check that actually what you're relying on is still right under the current regime. And one of the key differences is consent, and particularly in an employment context. And actually it's the employment guidance that my trainee was looking at that is out of date. So pre-GDPR, consent had a much lower threshold, so you could imply consent and you just had to demonstrate that you had some form of agreement to whatever you're doing. Now, of course, we know that consent has to be freely given, it has to be informed, it has to be fairly granular, and there are, I can't remember what all the requirements are off the top of my head, but consent is much harder to get now. It needs to be a positive indication from an individual and all those things. So consent post GDPR is used much less than it was previously, and it's certainly in an employment context, we hardly ever rely on consent from employees to do anything because it has to be freely given, and it's really difficult to demonstrate that consent from an employee is freely given if what they are consenting to has some kind of impact on their job or their role, or could have an impact on their job. And if we talk about vaccine information, for example, if VWV decided they did want to collect vaccine information from their employees, and they're saying to me, you consent to us using that information, if I refuse to consent, is there a risk then that I don't get a pay rise, I don't get a promotion, I end up losing my job? So I can't freely give that consent because there's that external pressure because of my position as an employee. So consent is not always appropriate in a post-GDPR world. So whereas guidance on the employment relationship under the old law would say consent is fine in this circumstance, it probably isn't anymore. So just a warning to be aware that there is still out-of-date guidance on the ICO website, and also to make sure that if you are relying on it, you've actually checked that out. Have the next slide, please, Emma. Thank you. So data sharing, I've included this because this is the area where I get asked the most questions, and I spend the most time scratching my head and trying to work out what agreements are needed, etc. Sometimes it's obvious and sometimes it's not. So when do you need a data sharing agreement? It is a legal requirement if the relationship is between a data controller and a data processor, or if the relationship is joint data controller, and I'll talk about what those are in a second. So it's really important to identify the relationship at the outset of the agreement. If you are separate data controllers and you're working together and you're sharing data, it's not a legal requirement to have a data sharing agreement in place, but sometimes it is advantageous, sometimes it's helpful. Sometimes you will want to have that in place, and that's fine, but it's not a legal requirement. It is a legal requirement in those two situations. Could I have the next slide, please, Emma? So data processor arrangement. For those of you that aren't working in the data protection side of things, a data processor is a third party, so somebody outside of your organisation, who is dealing with personal data. So you have to give them personal data, but they are doing so under your instruction. If you use Microsoft 365, Microsoft are your data processor, because you give them personal data when you put your name into a spreadsheet, or when you're typing, or you're setting up your email, or whatever it is you're doing. So Microsoft hold a huge amount of personal data about you and your clients and everybody else and your employees. But they don't do their own thing with that. All they are doing is providing you with Microsoft 365 and enabling you to access Teams or Word or Outlook or whatever it is you're doing on there. So they are a data processor because they're not using the data for their own purposes. If you are in a data processor arrangement, there are specific clauses in the UK GDPR which you have to have in your agreement. So you have to have a legally enforceable agreement. So it's not good enough just to have some notes on a bit of paper. It has to be a legally enforceable agreement between the two of you, and all of the clauses that are set out in the UK GDPR should be included. And I have lost count of the number of data processor agreements that I've looked at where there's 2 or 3 clauses just not in there. And I keep thinking, if you've put in the other 7, why not those last 2? Why would you just leave those out? So it needs to be all of the clauses. Joint data controllers. So a joint data controller is where you're both data controllers, so you are both making decisions about how and why you're using the information, but you're making the decision together. So if you are working with another local authority on a big, on safeguarding matters, so you work together because you've got a really close border and a lot of your schools across border and children go to different, whatever the reason, you're both working together on safeguarding matters. So you consult with each other and you make decisions about how to take things forward. In that scenario, you are likely to be joint data controllers because you're both making decisions together about what information you need, what you're doing with that information, where it's stored, who keeps hold of it, who has access to it, etc. So if you are joint data controllers, again, it is a legal requirement that you have an enforceable agreement in place between you. And that agreement must say who does what in relation to compliance. It is perfectly acceptable for that agreement to say both parties will deal with their own compliance. That's fine. That's perfectly acceptable if that's the way it's going to happen. In particular, you must deal with who will deal with subject access requests, requests for erasure, objections to processing, etc., and who gives privacy notice information. If you've said, so what we normally say in, I don't know, 80% of joint data controllership arrangements, we say both parties are responsible for their own compliance. In particular, each party shall be responsible for dealing with its own subject access requests, etc., and its own privacy notices. So that's fine. So we've covered everything we need to cover. That's all you need in the agreement. And of course, that's the minimum. If you want to, and we do have this in complex joint data controller arrangements, you can put in place whatever arrangement suits you. So it doesn't have to be that you're both responsible. You can make one organisation responsible and the other organisation's obligation is to assist you when you're dealing with that. That's perfectly fine, but it's whatever works in your situation. The other requirement that's not in the agreement is to make the essence of the arrangement known to individuals. Usually this is in the privacy notice. So you say, we act as a joint controller with X for this purpose, or something like that. That's probably all you need, depending on the complexities. But it's just, this is all about making sure that individuals understand that if they're giving their personal data to you, it's not just you that's accessing it as a controller. Somebody else might also be using it for that purpose as well. Could I have the next slide, please? So why do you bother with these agreements? Well, it is a legal requirement, so you should use them, because if you don't have them in place, it's a breach. But the key really is, if you don't have a valid agreement in place. So if there are clauses missing, if you don't have the agreement in place, then it's basically open season on who becomes responsible for ICO fines and particularly individual claims. And this is particularly problematic for organisations in the data processor arena. So let's say, and this is a silly example, but let's say you didn't sign up to the data processor clauses with Microsoft, which some clients haven't done. You didn't tick the right box. If Microsoft has a massive data breach and all the information that you have given them is suddenly leaked all over the internet, it's all accessible, all the sensitive data, everything. If you tick the box and you've got those clauses in place, Microsoft are responsible for that. They're clearly responsible for the breach, and they will be the one who has to pay the fine, and they have to pay the individual's claims when they inevitably make them. If you don't have that agreement in place, the ICO can, and in the example of Microsoft, they probably wouldn't because Microsoft have deeper pockets, but they could come to you as the data controller to pay the fine. And in particular, individuals can make a claim against you as the data controller, even though the breach had nothing to do with you and it clearly wasn't your breach. You don't have the right agreement in place. So as I said, that means there is a real risk of that happening. So if you don't care about the legal requirement aspect of it, it's really important in terms of protecting yourselves and protecting your organisation against those claims. So really would urge you to think about these things when you're putting those contracts in place. Next slide, please. The future of data protection in the UK. So I'm going to go through this slide really quickly and then we'll have a break. So as I said, there's currently a consultation on some significant changes, and of those that I think are most relevant to this audience, the UK government is looking at adapting the law for artificial intelligence and machine learning. There were some examples a few years ago of councils using some interesting technology around, I think it was council tax fines, I can't remember what it was, but some software that was doing some quite clever things. So if you are branching out into that and you're looking at using artificial intelligence, machine learning, etc., that should be, according to the government, made easier. So that's what they're trying to do. They're also looking at changes to the accountability framework, and that may mean changing the DPO role for public authorities. So there's a sort of suggestion that I think the government wants to go with only public authorities having to have a data protection officer in place, which means that there's a whole group of people who could potentially be out of a job if this does come into law. But they're also talking about changing the roles so that it's easier to find someone with the right credentials, because I know when clients come to me and say, oh, we need to appoint a DPO, but we can't find anyone who actually knows anything about data protection law, it is really difficult to find someone that meets that criteria. So they're looking at sort of changing that, I guess, to make it easier. Dispensing with the requirement for data protection impact assessments. There'd still be some sort of requirement to do a risk assessment, but there'd be no legal requirement. Removing the requirement for an Article 30 record of processing activities, which none of my clients have anyway, but you're supposed to have one. Most clients are supposed to have one, and then you won't have to have one, so that's great. They're also looking at amending the subject access regime so that, and basically pulling the Section 12 and Section 14 exemptions into subject access requests. So those are, the Section 12 is the cost of compliance exceeds a certain value. So if it's going to take longer than 18 hours to deal with the subject access request, you won't have to. And also vexatious requests. And that would be a huge leap forwards as far as I'm concerned, and as far as I think all my clients are concerned, because there are quite often requests that are clearly vexatious, clearly intended just to cause trouble and be a pain. And actually that would give organisations the ability to just get rid of those and not have to deal with them. And the government also wants to make changes to allow the better delivery of public services. Not quite sure what that means or how they're going to go about that or what that has to do with data protection law, but that's what they're saying. So there's this massive long consultation document with loads of sort of great sounding practical changes, some fairly fundamental changes to data protection law which the government are proposing. the reason I don't think a lot of these will end up being implemented is that if we make significant changes to the data protection regime, so we're no longer similar to what's in the European GDPR, which we used to be obviously underneath, our adequacy decision is at risk with the EU. So what that means is, at the moment, data can flow freely between us and the EU as it did before, so there's no issue with data flows. If we change the UK GDPR and the EU doesn't like the changes that we've made, they will stop that, and no data will be able to flow from the EU into the UK without putting those safeguards in place, so without having standard contractual clauses and all of those things, which isn't a huge inconvenience, but it is an inconvenience, and it may put people off working with the UK. So my view is that that is likely to be a stumbling block to any changes we want to make to data protection. But that's my view. I don't know, the government may decide they don't care about data flows and they'll put it through anyway. But at the moment, it's just a consultation stage. If you are interested, and actually there are some elements of it that do affect specifically public authorities, and so you guys, I would recommend having a look and thinking about whether you do want to comment on some of those proposals, particularly if you think they're helpful or if you think they're unhelpful. It would be useful for the government to pick up on that and know actually what people are thinking, because it's all sort of pie in the sky thinking at the moment, and it'd be really good to get actual individuals on the ground who are actually having to deal with this and interpret this to look at it. Thanks for comment in the chat box. Apparently the Environmental Information Regulations Refusing Request Guidance page has been changed and some of the exceptions are now missing. I didn't know that because I haven't had to look at that guidance recently. So that's not at all helpful, but I suppose useful to know in case you are having to go back and look at those. So I just wanted to give you a really quick update on personal data, just because I asked a trainee to do some research into this recently, because I've had a lot of clients recently who are subject to FOI have been dealing with requests for a lot of statistical information, sometimes around sort of COVID, how many employees are still working from home, how many employees have been vaccinated. That's not information that we would give out, but that kind of information. So if you are looking at a sort of statistical request, the first thing that you need to be absolutely clear about, if you're going to try and withhold it on the basis that it's personal data, is that specific individuals can be identifiable from the numbers. Now, in the case of vaccine information, for example, let's say that you hold that information, you've got 200 employees and 100 of them have been vaccinated. That's not personal data, because you can't identify which 100 have been vaccinated just from that information. So you can't use the personal data exemption if you hold that information. So it must be that you can actually identify specific individuals from the statistics. And the risk of identification must be more than hypothetical. I did have, a long time ago now, I had a case about this where this was a school had been asked to release 11+ data, exam data, and the requester wanted the month and year of birth of each individual who took the test and their test score. And the school said they weren't going to release that because they thought it was personal data, because they said that if you took information that was already available in the public domain on social media and through parent forums, you would be able to match those scores to individual pupils. Sounds great in theory, but what they couldn't actually do was give me an example where they could say this month and date, year of birth, and this score relates to Vicky Bowles, because actually there wasn't enough information out there in the public domain. So whilst theoretically it might be possible and it may be out there and you might be able to find it, actually if you can't, then it's not personal data. So it must, so you must, the easiest thing to do is to work through it and demonstrate, if I Google this then I know that this statistic relates to this individual, and then you've clearly proved that that is possible. And again, a lot of my clients use this less than 5 approach. So if there's less than 5 individuals on a statistic, they'll just say, so if there's 3, they'll just say less than 5. But actually, unless those 3 individuals are identifiable, it's not personal data, so you're not allowed to do that technically. Now, that's very low risk, but just so that you know, the ICO has actually said they don't like that approach. You still need to go through is this personal data? To be fair, in reality, that's not always possible, because if you're dealing with a request for a huge amount of statistical data, and you're worried that actually you might be able to identify some people from it, but maybe not from all of it, the last thing you want to be doing is going through pages and pages of Excel spreadsheets to work out specifically which ones are identifiable and which ones aren't. So you use the blanket approach, and I think that's perfectly acceptable, and you can always sort it out if you get asked for a review, but the ICO does say they don't like that approach. Next slide, please. So trends in the sector. So I just had a quick look at the enforcement notices that have been given to public authorities, and to be honest, at the moment it's generally just Section 10 notices. So someone makes a request, the authority hasn't provided the information within 20 working days. In most of the cases, by the time it got to the ICO and the ICO issued the notice, the information had been provided, but of course they've got to go through this process, so they just issue their statement that just says, okay, yes, it was late, but the ICO did say that during the pandemic they did accept that there was going to be a huge number of requests that were going to be late, because everyone was working from home. It's harder to access the information, and particularly at the beginning, no one really knew what was happening. Some people were on furlough, all of those things. So there's no penalty associated with that, but of course it is a statutory deadline. So legally speaking, it's late if it's late. So it is a breach of Section 10, but nothing gets done about it. So it seems a bit pointless, but that's where we are. So it's mostly Section 10 notices. There was an interesting case from Shropshire Council. I can't put my teeth in today either. Somebody had asked for, they wanted to know whether, or details of complaints made about specific individuals at the council, and I think it was a couple of specific councillors. And actually the ICO said you're not required to provide obviously the detail of the complaint, even if it's anonymised, because it's the personal data of the councillor, because it's a complaint made about them. But also there's no requirement to confirm or deny whether or not you've had any complaints, because that in itself is personal data. So if they, so for example, if Shropshire had said, oh, we don't hold the information relevant to your request, that actually reveals that no complaints have been made, so you don't even have to go as far as saying that. So that's helpful if you get those kinds of requests. Next slide, please. So trends overall, there were a few interesting practice recommendations. So these are not enforcement notices, but these are situations where the ICO has received generally a high volume of complaints about a particular organisation, and the ICO looks at where there are patterns in the failings, and they then release a practice recommendation which basically tells the authority what they need to do better in future. And it's not just about timescales. So if you have been late with a huge volume of your requests, and you know that you've had a big chunk of complaints to the ICO is not going to issue a practice recommendation just on that basis. There has to be more. And one of the key things actually is the ICO is looking at whether public authorities are following the code of practice and the general sort of best practice requirements. Not responding to the ICO is a factor, and I'm quite surprised at how many organisations just don't bother to respond to the regulator actually, but there we are. So if you're getting letters from the ICO, respond to them, even if it's just to say in words to the effect of, I haven't got time to deal with this right now, but I will send you a report, a response in due course. But actually respond, acknowledge the fact that you've had the letters. It's a really simple thing, but it can make a big difference. a lot of them were about delayed internal reviews. So there's no legal timescale. So unlike with the initial response has to be within 20 working days. When you do your internal review, there's no legal time limit on when you have to do that. But actually best practice is within another 20 working days. And the ICO was looking at, it was two organisations in particular that I was looking at, where the internal reviews had been delayed much longer than them. And not only had they been delayed, the requester wasn't updated, so they weren't given a timescale, and they didn't update them. If they were given a timescale, didn't update them when it wasn't met or anything like that. So actually, if you are doing your internal review, try and stick to that 20 working days. Or if you want to extend it to, say, 6 weeks, that's fine. And there's nothing to stop you doing that. It's not best practice, but it may be more practical in terms of who you've got to get to do the review, etc. But if you're upfront with the individual and you give them that timescale at the beginning, that will help with that. There was a lot of instances where authorities were ignoring requests for information in a particular format, and actually an individual does have a right to say they want it on paper, or they want it in a Word document, or they want it in an Excel spreadsheet. You don't always have to comply, but if you're not complying with that request, you have to, at least internally, show why it's not reasonable. So perhaps because the cost of printing would be too much, that's a reasonable decision not to release something, not to print something out. I'm always nervous about authorities giving information in Word or Excel formats, because those can be manipulated by the person in receipt. So I think it's perfectly reasonable to provide a response in a PDF format, even if they've asked for it in a Word format. But you have to consider, but if it's something that's so benign, even if the requester did make amendments to it, it wouldn't make any difference. It's probably not reasonable to insist that they have it in a PDF format. Also, a couple of authorities that required the use of a specific form to make a request, or in one case, an online portal. You can't actually force an individual to use a specific way of making a request. They're entitled to make it however they want. So they can make it on social media, they can make it by email, they can make it by letter, however they want to do it. But you can have forms to make your life easier, but you can't require somebody to use the form. So if they refuse, you still have to deal with the request. And a lot of non-compliant responses. So, and I see this quite a lot in my role. So when you're drafting the response, you have to say whether or not, and these are legal requirements. So it's not just, oh, this is the best way to do it. This is what you are required to provide. You're required to say whether or not you hold the information. And obviously, if you hold it and you're providing it, that's quite obvious. You don't have to go through the process of saying it. But if you are withholding it, you have to say whether or not you hold it in the first place. And if you're withholding it, you have to say which exemption you're relying on and why that exemption applies. So it's not good enough to just say, applying this exemption because it's personal data. You have to explain then why release of that personal data would be a breach of the GDPR, which is usually why you're releasing, why you're withholding on the basis of the personal data exemption. So you have to go further than just citing the exemption. And you have to tell the individual that they've got the right to make an internal review and that they've got a right to make a complaint to the ICO. And that bit's quite often missed out of the bottom, but that information is also required to be provided. Now, I don't think the ICO is going to be particularly concerned necessarily if you haven't told the individual they also have a right to complain to the ICO, because of course, if they do complain to the ICO before you've done the internal review, the ICO just says, go back and ask for an internal review, but it is still required to be on them. I think the key thing is really it's explaining why the exemption applies, because that's the bit that most often gets missed. And finally, there is a legal requirement for you to provide advice and assistance. So if you get a request that is too big and you refuse on the basis of section 12, you are actually required to suggest how the individual can narrow that request in order to get some of the information that they are asking for. That's not always possible. And I can't think of an example off the top of my head, but I have seen ones where knowing what the individual wants, there's no way that you can narrow it down, because if you narrowed it down, they're not going to get the information that they're asking for. but you can say that. I have considered whether we could provide you with some advice on how to narrow your request, but we can't, and that's fine to say. So, but do bear that in mind. It doesn't just apply to section 12 as well. If an individual's asking for something that you know is exempt, but you could provide something else that they haven't actually asked for, then perhaps you can offer that, and that helps show that you're transparent, provided you're happy to release that, obviously. So lessons to be learned from the practice recommendation: answer the regulator if they get in touch with you. Have a look at the way that you deal with requests and make sure that you are responding to them in as much detail as you can, that all the required information is in your responses, and look at your timings. So that's all. You'll be pleased to say all I want to. You'll be pleased to hear that's all I want to say about information governance. So it's over to anyone to ask any questions. I don't think we've got any in the chat box, but I'm happy to, and I'm sure Alison's happy to take any if people are happy to pop their microphones on and ask in person.
You've obviously answered everything, Vicky.
Yeah. Or everyone's gone to sleep.
Thank you very much for all coming along and attending today. It's just lovely to see everybody, and as I said, hopefully we can do this face to face soon, and have a proper catch up.